here. So I put this wonderful quote on the board. We start domestic violence today. On the schedule, it looks like we, I'm sorry? No, we're actually behind. So we start domestic violence. Again, on the schedule, it looks like we ended because there's just a, the Vaughn case and a couple of things on the schedule. But I sort of keep coming back to this issue, and it actually overlaps a lot with CSA, with child sexual abuse, that will start next week. For next week, just start doing the readings in CSA, but I promised you, and probably in Tuesday in class, I will actually hand you out the child sexual abuse case study that we're going to use as you read both the care and protection cases and the criminal child sexual abuse cases. And then I'm going to actually put you into roles. We're doing a simulation that we'll probably do next Thursday. Okay. Now, let's take a look at the Vaughn case, but sort of do it in a hypothetical way and have people argue about the varying interests of the child and the family. What's different about Vaughn, just procedurally, from what you've read so far? So we started care and protections, and you've read, most of the cases that you've read have been cases that started as a result of, Chapter 119 in the juvenile court. So why Vaughn? Why did I give you Vaughn in your, on at first blush, maybe it belongs in the family law course rather than the juvenile law course. Why do you think I gave you Vaughn to read? When was Vaughn decided?
1996.
96. You're all quick with the years. I never know the years. I'm flabbergasted that you. Oh, it's right in front of me. I never have the case in front of me, so I go from memory. So I guess that's why I never remember the year. Who wants to answer my question?
Well, no. I think I knew all the parties that lived there during this period, so I might.
What did you say?
I lived there. I know all these parties.
Oh! So Mark's going to tell us about the case.
No. But I think basically what you wanted us to read this for is because it deals with one abuse, like between parties, like 209A protection orders, and also
we'll get to what that means.
Pardon?
Go ahead, we'll get to what 209A means.
And also the rights of the child in custody and terminating a parental right. It's a combination of everything in this case.
Okay. Who else wants to add to that, Leslie?
I think it also kind of leads into the sexual thing because there's stuff in here about the mother naked.
All right. Okay. All right. Okay. Joe?
I thought it brought out really interestingly the competing interests, because it's not, in this case you really see what's best for the child, what's best, but then what the father would want and what the foster parents would want.
Okay.
So I like the competing interest aspect.
Amen.
I also noticed that there's a lot going for evidence.
There's a who?
There's a lot of issues going regarding evidence in this case.
Right. Right. Maria, why are you hiding?
No, I'm not hiding. I'm just reading.
I can't see you behind the pole.
Okay, here.
You have to move.
Let me tell you. What I was reading is that, because what I found interesting is that the domestic violence in this case, it wasn't only the man, it was they were going at each other. And then you have the custody battle of the child as well. So, and that tends to be from the cases that we had, I'm here people, from the cases that I had working as a social
we'll discuss that point too.
There was no agency really involved. This all came out of a probate family court, so this was like, they weren't
Exactly.
really married.
A custody battle,
But it was just
right?
like a custody battle, so there was no real agency brought in, so it wasn't like they didn't have to go through the emergency hearings or any of the other steps that we've done previously.
Somebody want to give me the facts of Vaughn first? Karen?
Well, you have two dysfunctional parents, basically. A mother who, a woman who had been previously married a couple of times, had two children from a previous marriage, and both parents were substance abusers in their history. Together they had this third child, Vaughn.
Okay, so when you say the third child,
They started out there, they met in Maine, eventually moved to Nantucket where the case takes place. It's the scene. She becomes more successful than he, becomes really, I think, the primary support of the family. The case talks about that she's become successful, makes probably more money than he does. And he becomes, there's just a history of abuse where the other two children, who are older children, talk in the case as well, that they
whose children are the oldest?
they're hers from a previous
Yes,
marriage,
okay.
and together they have this little boy who at the time is about 4 years old when the divorce is started. And the other two children talk about the history of this family, how they've all seen the emotional and the physical abuse by both parents. They talk about how she taunts him physically, how she'll go in and, she's appeared naked in front of the kids, that taunts him sexually, how he threatens her, threatens the children. So this is really a dysfunctional atmosphere for all of these children. But he loves this little boy, Vaughn, and has been a primary caregiver to the little boy, and that's the big issue here. I think that just because we don't see any abuse, him abusing Vaughn. We see, if anything, he's giving Vaughn too much attention, and that but Vaughn seems to be doing well in school. He seems to be, from what the court says, he doesn't seem to be affected at this point by all of these things that are going on in the home. So what the court does is...
Wait, just facts. Any other facts that Karen hasn't mentioned? Yeah?
I was just going to say that
Jamie?
there was a little bit of abuse towards him. I mean, he showered with Vaughn and massaged him, and I don't know, it sounded like, he really did love his son, but maybe a little too much.
So Dad showered with Vaughn and massaged him. Well, what other facts?
And said if he embarrassed him on several occasions at sporting events, maybe a little too over.
What else do we know about the parties, Ross and what's her name? Leslie. What else do we know about the parties? Karen told us a little bit about their relationship.
Well, they were alcoholics and into a lot of coke back then.
Okay.
And,
Okay. I'm calling you, Mark, because you mentioned 209A before.
Yes. She used to be a bartender at Atlantic Cafe, and she had she was a realtor driving a Range Rover. She made a lot of money, but this was her third relationship. She was drawn towards abusive people. And in this case, they were both not getting along, and I think he loved his son, but she tried to use the son as a tool to hurt him by getting the son away by making these accusations. Now, showering, I don't know how much of that is true. A lot of people, outdoor showers, big showers, whatever, after the beach, that kind of thing. So who knows how far the truth is.
What's 209A, Mark?
And that's when you have, if a person's like getting beat up or afraid of getting attacked by their husband or wife, he or she can seek an order from the court causing the other partner to move out of the house, stay away from work, not be able to make phone calls, and so on and so forth. If one of them happens to throw an object at the other person and they go to the hospital, they have to, by law, seek a 209A restraining order and arrest a person just to protect the other person. So that's what 209A is.
and 209A is basically, it's a statute that I haven't given you, but it also is particularly important.
It's an
If you're gonna be a,
emergency
you know,
petition.
practitioner in this area, just because domestic violence issues come up quite frequently. It's actually the abuse prevention law. And one statute that we may talk about later on is a fairly new statute, 258E, that actually allows, you know, non-related parties to seek abuse prevention, but I don't want to talk about that right now. It's a whole other issue. So 209A was, when it was originally first enacted, it dealt with pretty much, you know, husband, wife, boyfriend, girlfriend, household members. There was a change in the statute that allowed for dating relationships also to be included as part of the statute. But the reason why I asked, so we have in the facts of bond that at least I think by the time they're fighting their custody battle, there's at least one 209A, what's the word? Outstanding, I'm sorry. So what does that mean, that there's a 209A order outstanding?
It's a restraining order?
Yeah.
Well, that's
They
exactly
usually
what
go
Mark
for
just mentioned.
3 months or a year, and it's,
So it's still in
Still in
effect?
It's still in effect, so the order usually comes out of district court. Probate court also has the right to issue restraining orders as well. So it's an order out of district court, yet the parties are in probate court, you know, fighting custody. Another thing that I wanted to point out in the case that the court refers to the gender bias study. And that's one reason why the Vaughn case is particularly important. You know, today domestic violence is looked at as obviously a very serious issue and whatnot. It wasn't always looked at that way. Notice the quote that I have on the board from Alice Walker's famous book, The Color Purple. Wives is like children. You have to let them know who got the upper hand. Nothing can do better than a good sound beating. I remember, you know, practicing and going with people to get restraining orders in the district courts, and it was a very different atmosphere in terms of court support, not only through the clerk's office, but sometimes the judiciary as well, where abused spouses or abused victims sometimes didn't get the best treatment when they were seeking to get restraining orders. And I like the fact that we're using Vaughn as an introduction to domestic violence, because the abused spouse doesn't come across so well, right? And most of you, and I was smiling when I was hearing the facts, because most of you hit on, you know, the negative parts of Leslie's personality, which happen to be sometimes common characteristics of an abused, I'm saying victim because it could be man, woman, boyfriend, girlfriend, etc. They don't always come across so well. They don't always come across so well in interactions with us. They do, as Mark said, you know, end up in relationship after relationship that you know, hurts them and sometimes their children and whatnot. They don't always come across so well in court proceedings, where frequently it's the batterer that appears to have more control, appears more organized. It usually has more economic resources, so he or she can afford, you know, the legal representation. Very frequently, the abused spouse is coming in pro se to, you know, not so much the juvenile proceedings, because then you know you're going to have the attorneys appointed, but probate and family court, parties don't have a right to counsel in divorce cases and custody cases unless they're state intervention cases like the cases that we have. One of the things that the gender bias study, when you guys looked at the Vaughn case, what did you learn about this gender bias study? What did the court say about this study? Anybody know? I think there's just a short reference to it, so I don't know if you, Karen?
If they talk about how abuse of any family member affects all family members, basically. They say that the legislature and/or appellate court should make it clear that abuse of any family member.
Okay, that's when the court, and that's a good quote, when the court is talking about what abuse means. But what does the court say about the gender bias study? Jamie?
It says here the gender bias study concludes that our courts have too often failed to appreciate the fundamental wrong and the depth of the injury inflicted by family violence. In subtle and overt ways, the decisions of courts fail to take these factors into account and have them treated with insufficient seriousness in making dispositions, particularly in cases involving custody of children and the realignment of family relationships in divorce and related proceedings.
Yeah, and you know, one of the factors that the gender bias study looked at, one was sort of the myth, and it was, and maybe still is a myth, I don't know, that people tend to think that mothers tend to, you know, traditionally get custody just because they're mothers, you know, just because they're females, and the, you know, the notion that mothers and females can best take, when that was really not the case. That, and again, not really the case, because in the domestic situations, when you had, you know, husband versus wife, mother versus father, and the woman tended to be the abused victim, that she not only didn't have the resources in terms of the legal battles, but didn't come across as well, as organized, as mentally, you know, in charge as the father would. So just some of the things to think about. You know, it looks like, as you know, Karen pointed out, you know, that they're both dysfunctional. But you know, think of the reasons why they're dysfunctional. Think of the reasons why Leslie is dysfunctional. What about the? And I want to get to Karen in her position as GAL. What about the experts? First of all, the expert that they agreed on, Dr. What was the doctor's name?
Jaffe, the GAL, but the other one was Jaffe.
Jaffe was the one that they both agreed. No, Jaffe was mom's.
No, Abruzzi.
Abruzzi was the
Wait a minute.
That was the GAL.
Abruzzi was a GAL.
That they both agreed on. Okay, all right. Karen, tell us about Abruzzi, the GAL.
Well, he was a clinical psychologist, and I think they talked about him spending some time and doing some type of evaluation, although, and he did write a report, and he did recommend joint custody. And
does the court tell us what his qualifications were?
clinical psychologist.
Okay. But in terms of domestic violence?
I don't think they felt that he had as much experience as mom's expert, but
Right.
I don't think they
Right.
were any more
Right.
specific than that. Yeah.
Okay.
So.
And so tell us about him and what his findings were and what he.
So he recommended joint custody to be continued, but primarily on with his father during the week and weekends with his mom. And he didn't say anything about domestic violence according to this.
Right. Okay. And then mom's expert, Jaffe.
Right, and Jaffe did know a lot more about domestic violence. He was a specialist in family violence and battered women syndrome. And so he talked about Leslie having been an abused child, and the two previous relationships. And so he talked more about the effects on the child as well.
What is battered women syndrome? Now we will call it battered women syndrome, but.
I think it's really a woman that's being abused by her husband so much that she's always in fear of her life. So even if she's in a situation where she's not really in danger, but she feels in danger constantly because she's so used to the abusive situation.
What else? How else would you describe it? there's so many different ways to describe it.
Can't escape. She wants to kill the husband because that's the only.
Yeah, we laugh, but it's it. You're
But
right.
she feels
Yeah.
like she's somewhere where she can escape and her life is at stake. Her children's life is at stake, and that's what she can do. But maybe kill him, and so she can get away.
Do you guys know who the, Karen used the term expert in domestic violence and battered women syndrome. Do any of you know who are experts in the field that you sort of see, these names? Dr. Phil. Well, the famous expert is Lenore Walker, who came up with, talked about, I don't know if she came up with it, but she certainly publicized it, the whole cycle of, and she looked at it as, a circle, sort of, with, and I want to get to in a moment exactly the different types of violence, but the easiest way to describe it also is obviously the physical violence. And the way, you've got one.
I do.
Hold it up to the class, the circles.
You want to? Yeah.
I'll try to send, I have one electronically that deals with not only the abused spouse, but also the children's side of it. I have two wheels, if I think of it, and I believe I have them both electronically. I'll send them to you.
What year did
Um,
what did you?
Well, Lenore Walker's been around since, God, the 80s, I think.
Yeah.
So she came up with this, and the way it's described is that you have sort of the period sort of leading up to the violence that can be very sort of tension-filled, but where, again, the abused spouse is trying to make that not happen. I'll do what you say, I'll cook you meals, and then some incident or some statement makes the violence occur. So you have the period leading up to the violence, and the violence itself, the incident where the victim is actually hurt in the physical situations. And then right after the victim is hurt, what is called the honeymoon period, where the batterer, feels bad, I'll buy you roses, this will never happen again, I'll be better, and then it starts over and over again. Now, another, and I can't remember what the other expert's name is, or who all the experts in these fields are. I'm certainly not an expert, but that looks at it as not a circle, but more like a straight line, where the batterer is really just always in control, and then for example, the GAL report that I authored that I gave you guys, the little girl said to me once, and she just hit it right on the head. She said, my dad's always wants to be in control, but when he's not in control, he's out of control. So it's more like, rather than circle, just like line. So it's mostly, and actually in maybe the less physical episodes, the less physical violence is when you more see it as a straight line, with all the players sort of, under the control and trying to make things peaceful and happy, most of the time. There's tons of literature out there, scientific, sociological, etc., that deal with the effects, and that's what we're more interested about, the effects on the children. The little hypothetical, for example, that I gave you the other day, where the children were not physically hurt, but there was certainly some emotional injury, and for years and years that notion was really not recognized. If they weren't physically hurt, Vaughn was the child, right? Vaughn was not physically hurt, but what were the effects of living, year after year, seeing your parents fighting, seeing your parents, hurting each other emotionally, physically, etc. And now that certainly is looked at as a huge factor in terms of not only the state intervention cases and DCF's service plans with families and whatnot, but also in terms of custody.
In Vaughn, there was something mentioned about how Vaughn himself was not abused or anything, but because he was living in that sort of lifestyle, he would have grown up to become an abuser himself. And there's a field of study that says that all of this begins in your childhood. If you have you have parents that are abusive sexually or physically, like say the male will grow up to become one himself, and the female will grow up seeking someone like the father who's abusive because she couldn't change him as when she was a child. So in her mind, Ken, as an adult, she seems to get into that pattern, and once they realize they're in that pattern, they can break it and get out of abusive relations forever.
Never. And then
Well,
it's a happy
they
ending.
But really, it's they
Yeah.
are gravitating towards someone like their parents in future Mason. That's where the destruction begins in their new life.
Yeah, for example, in the jail report that I gave you guys, I saw that with the two little girls. The younger one was like a little mom, was just like her mom. Did everything to please her father, was always nice to everybody. She's the one that would be happy to see me. How can somebody not be happy to see me? But the older girl was just miserable. And while she had the most problems with her father, she was more like him. So that's exactly what you're saying, Mark. So they take on, it's the behavioral characteristics that the children, take on. So, one of my questions on the domestic violence questions that I gave you is, what is the typical profile, number one, of a batterer and people that are battered, and is there really a typical profile? We mentioned battered woman syndrome, and immediately, we heard about, more about physical violence. So what are the different types of violence that occur, and what is the typical profile of a batterer?
That's the thing. Do they often have lower self-esteem, batterer?
Can you combat that? So, in other words, on the surface, now I was just telling you about cases where I've seen,
they're not
and certainly, maybe even when the Vaughn case was being litigated, now, that the batterer may actually come across as if he or she is actually very confident, but they may, individually, have low self-esteem, so that's a good point. What else?
They seem to be always focused on themselves, like what they're not getting, what they need to get. They don't look at what
My child.
They're
I
very
have the
possessive.
right to visitation.
Like they own these people.
They're very possessive. of
Whereas
relationships.
sometimes you'll hear the other party saying, well, it's my child
Needs this.
not I need to have.
Narcissistic.
And that's exactly, that could be an aspect. Ed?
I think it comes up to control.
Yeah.
You have to control what your wife does. You have to control what your kids do. You have to be in charge when you're not there. They have to be in control. When they're not in control, they feel like they're losing control.
Right.
That's when they strike out. That's when they become.
So in the Vaughn case, when obviously, so they sent it back down. So if we were flies on the wall, when they sent it back down, what should the court do? I mean, you have two parties that have a child. There's certainly a history of domestic violence. Leslie does appear to have the behavioral characteristics of battered woman. Ross does appear to be a batterer, but they have a child together. And so in terms of deciding issues like custody and visitation, what do you do? If you were the judge, Amy, when a case went back down, what would you do?
Well, once the woman is out of the relationship, the woman has more opportunity to overcome the brainwashing, if you would, if she's able to get help. And she's where the batterer, unless he's really gonna go and get help and get really effective cognitive behavioral treatment, he's more apt to stay in that same mode and continue teaching the child that behavior, where the mother has an opportunity to kind of break free potentially.
And so you know how the court said you've got to comply with Chapter 2A, Section 31 and 31A that deals with, you know, if there is domestic violence, and you're going to, as a judge, make specific orders as to custody and visitation and whatnot, then you've got to make findings. So what sort of findings would you make? First of all, what would your decision be? Are you going to give, first of all, you know, are you going to give Ross custody? If you're not going to give Ross custody, you're going to give Ross visitation.
I don't know about the visitation. For the mother, I would give the mother custody, and I would give her a service plan just like they do in the other cases, and give her the opportunity to get out of the situation and help her cope with battered women syndrome.
Now, they first started fighting, you said, Karen, when Vaughn was 4, but for the case, by the time all of this is going on, the Vaughn is like 11, right?
14. When he was 4 is when they first started, you know, the disputes.
Right, right.
You know, that's when, the first restraining order, I think he was born in 92.
82.
82. And in 86, the first.
Other Karen? What we said?
Wasn't Ross ever physically abusive to her kids before Vaughn?
No, but that wasn't my question. What I was saying was, I was just trying to establish, so when the case goes back down to the trial judge, to the court again, to the trial court, Vaughn is now 11? Okay.
Your kid supervised.
No, it's 14.
He's 14, okay, I'm thinking he was 11.
When the
Okay.
SJC case, the appeals court decided the case, he was 14. So then by the time it goes back down, you're looking at a child who now has the right to assert
Can we
that
can we say he's 11 for purposes of the discussion? Is that, 14, yeah. And you're the judge, all right, he's 11, so you know all of this. What are you gonna do?
Supervised visits.
So, not custody, not visitation? Yeah, well, I heard from Mark before and from Karen that Ross pretty much he was in charge of Vaughn from when he was around 4. Is that correct, Dana?
Yeah, 5 to 11.
This means that.
Yeah, the mother seemed to be the primary caretaker from like 0 to 5, and then father took over from like 5 to
So how do you take those facts into account in making a decision?
It's best for the child.
Debbie?
Yeah, when I was reading this case, that was the problem I had, that the father getting custody. I think, in my opinion, the both are not fit parents because they both have issues. So maybe they should have, supervised visit.
Who? It's parent versus parent. We don't have DCF.
Yeah.
Oh.
Maybe they should be given to foster homes. I mean, I
No,
know
that's
for-
not the issue. The issue is custody between the 2 parents.
Yeah, I didn't.
And then if you're
I
gonna
know.
give custody to one or the other, then visitation.
The case here was that both parents were abusive to each other,
Right, yeah.
but Ross was never abusive towards his son. And knowing the people, and you're not seeing them as I knew them, and he should have had the custody, but the mother had a better attorney, Carol Witt. That was it was a case of attorney against attorney.
So what didn't happen?
That'll the experts. But this is what I want to bring you guys to, though. The judge now has to look at 20831 and comply with that statutory provision that says, look, if there's a history, you've got to at least look into it. And if you're going to award custody to the battered spouse, and again, on paper and legally, it's Ross that's the battered spouse because the 209A is outstanding regarding Ross. It isn't that you can't. It isn't that you can't, but you've got to very carefully be supporting your decision. Karen?
I think there needs to be an evaluation of Vaughn, and the court here talked about that, because nowhere in here is there any data about how this child is functioning.
Well, it says he was
Good.
doing very well in school, and He was doing really well. He had no issue.
Okay.
But they also went
On the surface, he's
on the
doing well
surface.
in school, but,
Right.
so you had the GAL, who was, whatever the name was, Abruzzi, and Jaffe, who was mom's expert, but truly no GAL that is really for Vaughn.
Well, they said though that Vaughn had gone to that Jaffe, with the parents prior.
True, but that isn't what a true GAL's function would
So
be
if I-
comprised of.
If I were the judge, I would actually keep things the same at this point in time, because one of the issues that I have seen is kids getting bounced around and
That's true.
moved, based on stuff going on with the parents that had nothing to do with the kids, and that can be very detrimental to the children. So I would leave things the way they were and have a much more full evaluation of Vaughn to try to figure out what child's needs were.
And what factors would cause a GAL, and ultimately a judge who agrees with the GAL, what factors would cause a loss of custody for dad, and possibly any issues with visitation?
Well, obviously, if there was any abuse going on towards Vaughn, that would certainly, be an issue.
Yeah, apart from direct physical abuse on Vaughn.
Stuff. Well, I think it would have a lot more to do with his emotional functioning.
Okay.
You know, is there any PTSD or other sort of trauma reactions to what he's experiencing? Would be what I would be looking for.
I think the father needs to be evaluated, because, I mean, look what just happened in real life with those two little boys. That guy was allowed to visit, and look what he did, because control issues can make people do crazy things.
That's true.
You know, and that kid could be in danger of losing his life because the father has such control that, hey, if I can't have you, nobody will. That kind of mentality. So I think they need
Right.
to focus on the father and find out what his mental status is and what
Yeah,
he's
because he was
capable
on
of.
that lithium and stuff, and then they said when he went off the lithium, his mental status was not good. So right there, that would ring a bell in my head about what type of mental status
Okay.
this guy had.
All right.
Isn't it also, there's so many cases though, like that, where parents kill their children.
Yeah.
You know,
Yeah, you have to look at him first. Father.
My only concern with, he was doing all the caregiving, he was the one that was going to school, he went to the kids' sporting events, he
That's
did
right.
all of the
That's right.
nurturing.
That's right.
But, I mean, he was doing all of that, so do you look at him, you know, did the mother have zero involvement only because she was working, or did she just not have an interest in it? And then I think if you were able to look at and see if what his willingness was, you know, will you go into a treatment, will you get it?
And by the way, remember
Do you do it?
the standard at that trial is the best interest standard. So again, the court is looking at, in terms of awarding custody, what is the best interest of the child?
I mean,
And certainly it ties into the parents' caretaking of the child, the parents' fitness as well. Karen?
One of the things that should really have been in the GAL's report, which maybe it was or not, would be some kind of an evaluation of the relationships between the child and each of the parents. So a good GAL report would include observations of the child or children with each
Right.
of the parents. So to give some, information about what is the connection like between the child and each of the parents, so you can, evaluate what the effect on the child would be to sever or, diminish or increase time with either parent.
And that's why when I was asking you before about their qualifications, it at least seemed evident from at least how the court reported it, that it's possible that this GAL really had no expertise in the field, that it truly is an expertise. Especially, in cases where you don't see really outward physical violence, and you really have to dig and understand sort of the behavioral characteristics and the, you know, the behaviors of all the people, you know, mother, father, and child. Mark?
How long has the court, or have the court been using GALs for children's rights? Basically, because a lot of these cases we're coming into are all 80s and 90s cases. Were GALs used much in the 60s and 70s? And
That's a good question. I started practicing in the 80s, and it was very sort of informal almost, on a case-by-case basis, and the court paid you, and in many cases, for example, if you have a custody battle in probate family court, somebody cries, we need a GAL, and then the judge says, you know, well, we don't have the money for it, and the other party's willing
Aren't
to
the
share.
courts dispensing now with GALs because you can't afford them?
Well, that's what I'm saying, that if the parties agree sometimes to pay for the GAL, but that typically happens in probate family court, not juvenile court. Karen, what is going on with your role in guardian ad litem in juvenile courts?
It's hugely diminished. I 4 years ago had more work than I could do. And I'm a clinical GAL, so attorneys can also be GALs.
That's
so
right.
There are different varieties and there are different types of GAL assignments. We can be making recommendations about medication or future planning or education. So there are different types of GAL. So GAL is kind of broad.
It is a very, very broad term.
But yeah, I had probably, I don't know, 20 families, and now I have 2. So we've taken a huge hit. But basically, we would get, a GAL would be appointed, the parties would request it, everybody would agree, or sometimes the judge would order it. You'd get appointed and the judge would say, you know, I want you to evaluate this issue, or permanency planning and placement, or education. And then you'd go off and you do your job, and there were rules about what you could bill for as a GAL.
Right.
But now, when you're appointed, you get 10 hours to start off with, and that's it.
Right.
So, which is absolutely nothing. I used to, my initial reports on kids would usually be about 30 pages, and that was easily 30 to 40 hours worth of work by the time you're done interviewing, because you have to interview the children and the parents.
That's right.
And DCF in the juvenile court and the school and therapists, and depending on how many people are involved, you can have, you know, a lot of information. You got to read the record in the court at DCF at the school, so it's a lot of information. So unfortunately, GALs are not being utilized very much, and I do think it certainly is to the detriment of the kids.
It is.
It's a lot of information that does not get into the court, for especially I find with teenagers, because they have attorneys who are representing what they want.
Exactly. Exactly.
The GAL
court will not learn the best interest piece of it unless the court gets it from the GAL.
Right, and that's been a struggle for some of the attorneys that I've worked with, because they really want the court to know pieces of information. For example, the teenagers who's saying, I want to live with my mother, where everybody knows, including the teenager, that she should not be living with her mother, but she can't say, I don't want to live with my mother. She has to tell her attorney, I want to live with my mother, because of the dynamics between her and her mother. So you have nobody else who can represent really what's best for the kid. So I think it's very unfortunate. And GALs can, like in education, I can do advocacy for kids with the schools, which can also be,
and that's been cut tremendously.
Tremendously.
What Karen was mentioning before when she said report, so the GALs are not to be confused with the court-appointed investigator who also does a report, and so by statute, that person still gets appointed across the board in every juvenile care and protection case. But if there is going to be a GAL involved, very frequently the GAL will also do some sort of investigation. And again, as Karen mentioned, there may be different reasons for the appointment, so it could be very limited in terms of what the GAL is reporting to the court, but was thought of as sort of like an arm of the court. The judge can't go out and find out those things. So it has been very helpful to the judges in the juvenile and the probate courts to hear from a guardian ad litem that would not only represent the best interest of the child, piece, that voice, but also would be sort of writing something up, would have some, would be doing some factual sort of investigation, and the judge could be, looking at a report very similar to the social worker's report, very similar to the investigator's report, but it's from an totally independent source, not siding with child, family, or state, but just keeping in mind the focus being the best interest of the child. So that's what a guardian ad litem is, and we'll come back to that conflict.
Yeah, the other difference between the court investigator and the guardian ad litem is that, technically speaking, court investigators are not supposed to offer their opinion to the court.
That's right.
Now,
That's
they
right.
often do, and as attorneys, you can get that stricken. But
and Kate must be doing some motions in limine
I'm
to
doing
do
a
that.
I'm doing a motion to eliminate a strike right now for a bunch of opinion in a court investigator's report.
Right, they're supposed to be all fact-based, whereas GALs, we have to have the facts because our opinions need to be grounded in the facts, but because we're considered experts, like the evidentiary kind of experts, so we can actually offer our opinion. But of course, it's all subject to cross-examination, but that is a difference between the two.
Yep. So, in any event, partly because the case was when was one decided? Which is, it's so recent, but yet, in terms of the litigation leading up to it, it certainly wasn't in its beginnings a recognition, a good recognition in terms of the players in the trial court system of the issues involved. But now, and especially more, I don't know, to a certain extent, I think the juvenile court practitioners, judges, GALs, etc., are actually more schooled in domestic violence, I think, I could be wrong, than the probate family court practitioners. Just because, in terms of state intervention, it's often a reason why DCF gets involved. It becomes an issue in DCF's, service plans in terms of batterers getting treatment and victims. Am I right? Maria, do you agree?
I do too, but I just have a concern. There is, well, we have to write the service plans, whatever we needed to write.
Right.
When in a case of domestic violence, we often find the problem of, what if it was the opposite? If it was the man that was abused, there's no batteries intervention program for females, but there is a...
So it's a services issue.
So the services, there was nothing available to support the man if he was the one being abused. Everything was, everything that we found, and we often, were questioned. So why doesn't she have to be forced to do a batteries intervention program? Why can't she do, if we were like, where do we go? There's really nothing available for them. And I'm not saying that, as a female and as everything, professional, I find that, it is actually a little bit biased because it wouldn't be fair in the cases.
And when were you doing them? You're not involved anymore, right? Or you're talking about around when?
Well, that was, I would say 2 years ago.
2 years ago,
yeah.
Okay.
And like the services we will refer to is the
program
at Holy Family Hospital is the only one that has the batteries intervention program. There was another program but it was just focused on men, nothing for the female and children. Yeah, but other than that, there's nothing available.
So if Leslie beats up on her wife, that means Leslie can get services. right?
Then they would have to consider.
Massachusetts, isn't it?
Which one
That's
is
what
the next.
Maria is saying.
That's why the
There's no program for you.
No, there's nothing for you. There's nothing available for you, so that, I thought that was just, you know,
Right.
weird, that at this point in age, there's nothing available, and it's, I think maybe the main reason is because, the report does not get, it doesn't get reported as often. And we often
Okay.
tend to look at the family, oh, the man is the one that is abusive. Let's take the kids away from him, but.
And you're mostly looking at heterosexual relationships.
Yeah, and that's
Yeah.
all, we're still focusing on that as opposed to other, changes.
One more issue that I just want to sort of briefly mention, just, we don't get into it per se because it's really not that much a part of the course, but in terms of domestic violence, and Aviva mentioned it earlier, and that's in terms of the really horrendous physical violence relationships where the battered spouse ends up actually killing the abuser. And I got involved with those way back when they were, we call them the Framing in Nine, a group of women that were actually in jail for killing their abusers. There was no defense at the time, and I forgot what her name was. One of them actually who got out came and spoke at one of my classes way back when. But, with sort of the rise of the courts, the judiciary, the legislature, the attorneys sort of getting more up to date in terms of these issues. The legislature actually enacted, and I can't remember what the site of the statute is, but there's actually a self-defense now in Mass statute. What is the site? Is it 276 something? That does allow a battered spouse to use the battered woman syndrome, or battered person syndrome as a defense. So that was sort of a huge thing in Massachusetts, because the argument originally was in terms of them using self-defense. Well, because typically and these were women. They were women at the time, that killed. I'm sure there might be instances the other way, but the argument was, well, he may have hit you, hurt you, horrendously, but when you killed him, he was asleep, he had no weapon, it was days later, weeks later. So in terms of the imminent threat, that was a huge, argument against. And it's still a big hurdle. I mean, you can use the statute as a defense, but you may or may not be successful. Did you want to say something?
No, I was just going to say, I think that's a ridiculous way of looking at it, because if you're being abused, if you had the ability in that moment to use self-defense, you probably would be. But usually the only time that you have a one-up on them is when they're sleeping. So, I mean, that's what I would do if I was being abused.
And then the other sort of big the other sort of big myth in domestic violence is, well, they can leave. Why can't they leave? And then the statistics show that the battered victim was in fact in the most danger when he or she did leave.
Doesn't it take 9 attempts before a woman actually decides to get out of a domestic violence situation? It says, I think there was a study that says it takes about 9 different attempts before they actually get out. So
Yeah, I mean, Karen mentioned before PTSD. You all know what that is, right? Generally speaking, but so you have the state intervening because you've got kids, you're being battered, and they can't understand why you won't leave, or why you're supporting your partner who's battering you. And there could be all different reasons. You know, Ed mentioned control before. There's all different kinds of, there's physical control, there's economic control, there's using the kids as control, there's using the pets as control. Maria?
And, you know, one thing that really bothered me as a social worker, again, is that we have cases of domestic violence. You have these women with all these issues, you know, thinking, oh my God, and I'm gonna leave and I'm gonna drop, you know, I'm gonna leave everything that I have in my house. They do think about the material stuff that they own, and they don't think about the quality of, you know, like getting, being alive with their kids. But then on top of that, they add the pressure of, if the case is involved with the department, that the department is forcing them indirectly, because we couldn't say you have to leave the house or your kids are gonna be removed, but that's another fear that they have. So on top of that, you have a social worker being forced by the supervisory management. That woman is to leave the house, if not
Right.
going in and removing their kids.
Right, right.
And you know, how much of that, there's a lot of pressure going on.
A lot of pressure, and again, the battered spouse, for various reasons, really just can't acknowledge or won't that it's happening, and as a result can lose custody. The same sort of thing occurs, you know, you're going to meet some of these child sexual abuse cases, and you think at first, oh my God, how did this, you know, mother, you know, stay with this guy and not acknowledge? But see, they're so tied in together, the DV and the CSA cases, because even with the child sexual abuse, it's still about control as well. Yeah.
I think maybe the woman is so much emotionally and psychologically abused. She loses her self-esteem, and then if she comes out, she thinks she cannot be able to take care of herself, and she'll be in fear of going out there. And I think that's also the reason why, because most of the time it's women keep coming back and coming back.
There was
or not leaving, just stay there and take it.
There was a horrendous case out in New York, and this was years ago, but her name was something like Etta Nissenbaum, the woman who was a beautiful, beautiful, intellectual, professional, met up with this lawyer, and I forgot what his name was. Her name was Nissenbaum. They adopted a child, a little girl, and he abused that little girl so much. She ultimately died. He killed her. But Nissenbaum kind of reminds me of this Leslie in Vaughn. You know, she came across also so well in the press in terms of that she didn't protect her daughter. But when you looked at the before and after pictures of this woman, she didn't have the capability, and it's very sad, she didn't have the capability to protect not only herself, but her child. And she was very obviously negatively looked at because of the death. Very serious cases out of that. Child sexual abuse Tuesday. I don't have anything else. Any questions on the process? I know people were confused a little bit. At some point, I'm going to have, she teaches here, Maria Fournier. She's a Department of Child Families attorney. She's going to come in and do a little talk with you guys, not only from the department's perspective, but she can, you know, sort of do an overview too of the process and get into some of the stuff that either that you need as a review, or you know, she'll talk about more specifics in terms of these cases and the procedure and whatnot. She might come on Tuesday. I never know. It depends on if she gets out of court in time or whatnot. So we'll keep going with the child sexual abuse stuff, but we'll obviously take a break if she's coming to talk to you. All right? You've done it, right?
No, not personally.
She teaches motions here too. She's great.
She's in Lawrence and Canton.